US Citizenship canceled. 5 ways you can lose it in 2026. Shocking rules. Visa status radar. YouTube script. 2,800 words. The letter arrived on a Tuesday. No phone call before it. No warning from an attorney. Just an envelope with a government seal. And inside it, language that a naturalized US citizen of 14 years described as the most frightening words she had ever read in the English language. The Department of Justice was initiating proceedings to strip her of her citizenship. The fluorescent light in her kitchen felt suddenly too bright. Her hands were shaking so hard she had to set the letter down on the counter. This didn't unfold over years of wrongdoing. It unfolded over one question she had answered on a form. One question, years ago, that she hadn't fully understood. A single omission that could erase 14 years of American life. A single omission that could destroy her children's future. A single omission that could put her on a flight to a country she no longer recognized as home. One wrong answer on one government form, and everything you built here is gone. What is happening in 2026 around U.S. citizenship has alarmed legal experts, immigration attorneys, and naturalized citizens across this country. The government's ability to cancel citizenship, formally called denaturalization, is not new, but the enforcement posture around it has shifted in ways that most naturalized Americans do not understand and have never been told. Most people believe citizenship is permanent. They make the mistake of thinking once you take that oath, you are untouchable. They fall straight into the trap. But today, you're going to do something different. For several years now, there had been signals, not from official USCIS press releases, not from published executive orders, just signals, that the federal government was preparing a more aggressive posture toward denaturalization than anything seen in recent memory. The Department of Justice had been expanding its denaturalization unit quietly, yes, but also systematically in that approach. Cases that once took years to build were moving faster. Referrals from USCIS to DOJ were increasing. Their actions followed a pattern, a prioritization, a targeting strategy, almost a checklist, that immigration attorneys tracking denaturalization cases began to recognize clearly by 2024. But what triggered open alarm among immigration legal organizations this year was that the pattern stopped being quiet. It became policy. The DOJ's Denaturalization section, which was formally reestablished in 2020, had by 2026 expanded its active caseload significantly. Attorneys who monitor federal immigration enforcement recognize the indicators: the uptick in civil denaturalization filings, the inclusion of denaturalization language in immigration court proceedings, the cross-referencing of naturalization records against criminal databases, fraud flags, and foreign affiliation registries, the sudden appearance of denaturalization threats in cases that had previously been considered closed. And when the government begins reviewing closed naturalization cases, something loud is coming for the people inside them. In early 2026, federal court records and DOJ case filings documented what legal observers described as a coordinated enforcement expansion, including denaturalization proceedings against individuals whose naturalizations had been approved over a decade ago, cases not revisited in over 15 years. These are actions the government only takes when signaling a structural shift in enforcement. A recalibration of what citizenship protection actually means in practice. A direct message to the naturalized citizen community about what is and is not safe. Or a deliberate widening of what qualifies as grounds to strip someone of their status. Legal observers weren't certain which interpretation was primary, or whether all three were true simultaneously. But one thing was clear across the documented cases: the government was changing its enforcement posture on denaturalization. And when that happens without public announcement, every naturalized citizen needs to pay attention. The warning issued by immigration attorneys and civil rights organizations in 2026 was not routine. It was not a theoretical legal briefing. It was urgent. Attorney after advocacy group described the shift as aggressive, unprecedented in modern context, and most importantly, targeting people who had followed every rule and still found themselves vulnerable because of technical grounds they never knew existed. The ACLU, the National Immigration Law Center, and multiple state-level immigration legal aid organizations issued guidance. Their response was among the most coordinated legal alerts seen in the immigration space in years. Because the 5 pathways to citizenship loss they identified are real, they are active, and most naturalized Americans have never heard of them. Here is what has been confirmed. Federal prosecutors and DOJ attorneys launched denaturalization actions in 2026, targeting individuals across multiple categories, including people whose cases had been administratively closed, people who had received citizenship through naturalization ceremonies with no fraud flags, and people who had lived legally and openly in the United States for over a decade. They acted before those individuals had any legal representation in place. They targeted individuals with prior criminal records that were not disclosed at naturalization. They targeted individuals with foreign military or government service connections. They targeted individuals connected to naturalization applications where procedural irregularities, not fraud, but procedural issues, had been identified in file audits. This wasn't symbolic. It was a legal mechanism with real removal consequences. And that's what made the 2026 warning so urgent for the naturalized citizen community. Let me walk you through the 5 specific ways U.S. citizenship can be canceled in 2026. Because this is not general information. This is the specific legal framework being used right now in active federal cases against real people. The first way is procuring naturalization through concealment or willful misrepresentation. This is the most commonly used ground for denaturalization and the most broadly applied. When you apply for naturalization, you answer questions on Form N-400. Those questions cover criminal history, immigration violations, affiliations with organizations, and a range of personal history. If you failed to disclose something, even something you did not believe was relevant, even something you disclosed elsewhere in your immigration file, even something from decades ago, the government can use that as grounds to denaturalize you. The legal standard is willful misrepresentation. But in practice, prosecutors argue that if you knew something and didn't write it down on that specific form, the concealment was willful. Courts have in many cases agreed. And in 2026, USCIS is cross-referencing old naturalization files against criminal databases, foreign government records, and social media content in ways that were technically impossible 10 years ago. The second way is illegal procurement, meaning you were not actually eligible for naturalization at the time it was granted, even if USCIS approved it. This sounds contradictory. It isn't. If, at the time of your naturalization, you had a criminal conviction that made you legally ineligible, even if that conviction was not disclosed, even if USCIS officers missed it, the naturalization can be declared void. The government's position is that an illegally procured naturalization certificate has no legal force. It doesn't matter that USCIS granted it. It doesn't matter that you believed you were eligible. The certificate, under this theory, was invalid the moment it was issued. Federal courts have consistently upheld this ground for denaturalization, and in 2026, it is one of the most active areas of enforcement. The third way is membership in or affiliation with subversive organizations. This ground dates back to the Cold War era, but it has not been retired. Under U.S. law, if within 5 years of naturalization, a person becomes a member of or affiliated with an organization that the government designates as subversive, anarchist, or opposed to constitutional governance, that naturalization can be challenged. The definition of what qualifies as such an organization has expanded in the current enforcement environment. It is not limited to terrorist organizations. It can include foreign political parties. It can include organizations that the State Department has flagged in connection with foreign government interference. And social media content, communications, and financial transactions are all being used as evidence of affiliation. The fourth way is obtaining naturalization through service or connection to a hostile foreign government. Under 8 U.S. Code, Section 1451, a naturalized citizen who within 5 years of naturalization takes an oath or makes a declaration of allegiance to a foreign state, or who serves in the armed forces or government of a foreign country without specific authorization, is presumed to have renounced their U.S. citizenship. This is not a new law, but in 2026, the application of it has broadened. Individuals with dual citizenship who performed any form of civil service, military reserve participation, or government employment in a foreign country, even briefly, even many years ago, are appearing in denaturalization review cases. Immigration attorneys are seeing this ground applied in situations that previously would not have triggered any government interest. The fifth way is perhaps the most disturbing because it requires no wrongdoing on your part. It is called derivative denaturalization. If you obtained your citizenship based on a family relationship, if you were naturalized as a child through a parent's naturalization, or if your citizenship derived from a parent who was later denaturalized, your citizenship can also be revoked. You did nothing wrong. You followed every rule, but your citizenship was legally derived from someone whose naturalization has now been canceled. And when that foundation is removed, the law allows the government to remove the citizenship that was built on it. Legal experts in 2026 have flagged this as a particularly urgent risk for adult children of individuals currently facing denaturalization proceedings. Now, I want to be precise about something, because fear without context is not useful. Denaturalization is still relatively rare in absolute numbers. Most naturalized citizens will never face proceedings. The majority of cases involve individuals with documented fraud, serious criminal histories, or deliberately concealed wartime atrocities. But the enforcement environment in 2026 is different from 5 years ago in one critical way. The tools available to the government for identifying potential cases have expanded dramatically. Artificial intelligence is being used to cross-reference naturalization files against criminal databases. International law enforcement data sharing has given federal prosecutors access to foreign government records they previously had no way to obtain. Social media monitoring and digital communication analysis are being used as investigative tools in ways that simply did not exist when many of today's naturalized citizens filed their applications. What this means is that people who made small errors, minor omissions, or had circumstances they didn't fully understand at the time of their application, those people are now potentially visible to investigators in a way they were not before. There are things you can do right now to protect yourself. The first and most important step is to obtain a complete copy of your naturalization file. You can do this through a Freedom of Information Act request to USCIS. Review every answer you gave on your N-400 application. Compare it honestly against your actual history. If there are discrepancies, even small ones, consult an immigration attorney immediately. Do not wait for a government letter. The time to identify and address a problem in your file is before proceedings are initiated, not after. The second step is to understand what your N-400 required you to disclose and whether you disclosed it fully. This means looking specifically at the questions about criminal history, including arrests that did not result in convictions. It means looking at the questions about organizational memberships and affiliations. It means looking at the questions about foreign military or government service. If you answered any of those questions in a way that was incomplete, even innocently, that incompleteness is a vulnerability. An immigration attorney can help you assess the risk and, in some cases, can help you document the good faith basis for any answers that might be questioned. The third step is to review your travel history and any foreign affiliations you have maintained since naturalization. If you hold dual citizenship, understand what obligations that citizenship carried and whether any of those obligations could be characterized as service to a foreign government. If you have family members who are currently naturalized citizens and who may be facing immigration scrutiny, understand that derivative citizenship risk is real and worth discussing with an attorney. The 2026 enforcement environment is not going to slow down. The tools available to investigators are becoming more powerful. The cross-referencing of records is becoming more systematic, and the legal framework that allows denaturalization has not narrowed. In the current political climate, it has widened in practical application, even where the statutes themselves have not changed. This is not meant to create panic. It is meant to create clarity. Because the people who face denaturalization proceedings unprepared, the people who discover the threat only when the letter arrives, those are the people who lose. The people who understand the law, who have reviewed their files, who have consulted an attorney, those are the people who can defend themselves. Citizenship in the United States is the most protected immigration status that exists. But most protected is not the same as unrevocable. And in 2026, that distinction matters more than it has in decades. As this enforcement environment continues to evolve, more cases will be filed, more families will be affected, and more naturalized citizens will receive letters they were not prepared for. But you don't have to be one of them. Knowing this does not make you a criminal. It makes you smart. It means you're prepared. It means you're protecting your family. Share this video with every naturalized citizen you know. It might be the information that protects everything they have built in this country. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of U.S. immigration enforcement unfolds.